the other option was to simply bring forward the claim before what was known at that time as the Indian Claims Commission. Now, the Indian Claims Commission was set up as a body to hear and determine basically claims from First Nations in Canada. But the big thing, ladies and gentlemen, was it was a non-binding administrative panel. So the Cowessess claim was broken down, as Terry mentioned, into two phases. So in 94, under Chief Lionel Sparvier at that time, 96, we decided to bring forward the claim before the Indian Claims Commission, and council was endorsed in that regard. And so there were two phases to the Indian Claims Commission. The claim itself was broken down into two essential phases. Phase number one was whether Canada had basically, whether there was a valid vote was number one. So whether the surrender was properly conducted in accordance with the provisions of the Indian Act, okay, and whether the required majority assent had been obtained from the band membership in January of 1907 with respect to the said surrender. So we made our legal arguments, we did our historical arguments before the Indian Claims Commission on the phase one hearing. And I just got to go back to our chronology here, but in 99, the Indian Claims Commission formally issued its decision on 2001 on the 2001 on the phase one inquiry. And they concluded on the phase one inquiry that a proper vote had not taken place in accordance with their view, and that a majority had not consented to the surrender. Following that particular phase of the inquiry, they wrote to the minister with their decision, indicating and recommending at that time that the 1907 surrender claim of the Cowessess First Nation be accepted for negotiation under Canada's specific claims policy. Now, it was as I mentioned earlier, it was a non-binding recommendation. Now, in March 27th of 2002, the then Justice Minister, Mr. Nault, advised that Canada, he wrote back to the First Nation. It was rather disappointing at that time, but after all that work that had gone into it, but they wrote back to the First Nation indicating that Canada was not prepared to accept the non-binding recommendation from the Indian Claims Commission. And then as a result, we then moved on to phase two of our inquiry. Now, phase two of the inquiry dealt with whether Canada had breached its fiduciary obligation to the First Nation in taking and procuring the surrender. And so we went to that, and again, a few years later, we made the arguments. We had the hearing on the phase two, and then Canada basically ruled it was a split decision in that particular case. So there was a number that Canada had breached otherwise. And again, shortly thereafter, the minister wrote back and to the First Nation indicated again they were not prepared to accept the claim for negotiation. So we were successful in the Indian Claims Commission on phase one. We had a split decision on phase two. Then we move ahead a few years, and then in 2017, during Chief Delorme's and his council's term of office, we regrouped as a team, and we decided that we would resubmit the entire 1907 land surrender claim for reconsideration. All of the historical documents, all of the legal arguments, and one of the reasons for that was there was quite a bit of developments in the case law surrounding surrenders and Aboriginal land, First Nation land claims across the country. So it was a unique opportunity for us in 2017. So Dan and I, we prepared the legal submission and the historical submission with the assistance of some of our contracted researchers at Joan Holmes and Associates had prepared a lot of the documents for us. We had a wealth of exhibits. We had a wealth of elder testimony. We had a wealth of studies that were part of the ICC inquiries that were done the years earlier. So we rolled all of those up in 2017, and we rolled them into a brand new submission for Canada to consider under the specific claims policy. So that was submitted in 2017, and then in there were some efforts made, and then in 2020, I believe it was, a formal letter was issued to the First Nation from the Government of Canada, basically advising in early 2020 that Canada was prepared to formally accept the 1907 land surrender claim for negotiations under Canada's specific claims policy. And the basis for the validation was quite interesting. They concluded that there was a pre-surrender breach of fiduciary. They were prepared to accept the claim for negotiation on the basis that Canada had breached its pre-surrender fiduciary obligation to the Cowessess First Nation in taking the surrender and basically losing a significant portion of the arable land from the Cowessess First Nation, the southern portion of its reserve, almost all the way to the railway and the village of Oakshella. So in 2020, we began in earnest in beginning the negotiations of this particular claim with the Government of Canada. One of the first agreements that we signed as a negotiating team was a protocol agreement that we would keep confidential. The terms of the negotiations and what was being discussed at the table was going to be strictly on a without prejudice basis. Now, early on in the negotiations, as Canada is accustomed to doing, before we even got into the studies that were required to be done as part of this claim, Canada put on the table an opening settlement offer that they were prepared to settle this claim for a set amount of money. That went to council, and council agreed that they were not prepared to simply accept the first figure that came about, that we would go through the actual legal work. We go through all the legal work and commission the studies associated with the claim. So what we did is we went through the normal process that we would in settling a large claim of this nature. So number one is we retained the services of a number of experts across who are known in their fields, and we commissioned various studies to determine the actual losses that could be sustained or were sustained by the First Nation. So one of the first studies that we commissioned was a current unimproved market value of the surrendered lands, all 27,704 acres. So we had an individual by the name of Dave Hoffman from Hoffman and Associates out of Yorkton, who came in and did a fair market appraisal of the said lands a couple of years ago. The second and perhaps the most important study of our claim was an agricultural loss of use study. And that particular study, we went and looked at the losses that were sustained or associated with the claim lands going all the way back to 1907 through to the present. And we commissioned that study was commissioned by a well-known expert by the name of Stan Lohr. Stan had considerable experience working on a number of other claims associated with First Nations for the last 30 years. Stan was technically retired, but he came out of retirement, him and his team, to work on this one last claim for First Nation and Cowessess, and we're quite grateful to Stan for all of his efforts, because his work resulted in some very important factual situations for us in terms of our history and how the said land was developed. The second study that we commissioned was a minerals loss of use study to determine the lost value of the minerals associated with the surrendered lands. Now, each of these studies, of course, they have a draft study, a draft report, and a final report. So over the last couple of years, and Canada has on their side of the table their own independent advisors to advise and give them advice on these studies and the numbers that are generated from them. So the main focus over the last several years has been to complete the required studies associated with the claim so that we could determine basically what the losses were each year from 1907. And there's two aspects associated with the negotiation of any land surrender claim. The first aspect is to determine your losses, and the second aspect is how you bring those losses forward in terms of compound interest. And there have been quite a few developments in the case law over the last 30 years on how losses are to be brought forward. So we had the benefit of a lot of legal arguments that we could make in advancement of our claim. Over the course of the last couple of years under the previous administration and under this administration, both Dan and I have been able to make a number of legal arguments. The negotiations have centered around a lot of technical issues about how to value the claim, certain aspects associated with the value of the claim. But over the course of the last couple of years, we've made a number of legal briefs. We've made a number of legal submissions to Canada and their legal counsel. And those have culminated, ladies and gentlemen, in the claim going to different levels, different echelons in terms of value. And so, the claim itself is, we were constantly telling the council is, I don't know, how much more juice can we squeeze out of this lemon? And we're squeezing every cent that we can squeeze out of these guys. And finally, we got to a stage, I think, last December here, where the value of the claim is very significant. It's a significant high value claim compared to other claims in the Prairie region. And so, I think through all the efforts of the previous councils of the day, this current council, our negotiating team, we've been able to bring this claim from, $0 when we picked it up 30 years ago to potentially one of the largest claims in Western Canadian history. We can't disclose the value of the claim because we're under the protocol agreement, but as Chief Beaudin has mentioned, where we are right now is that we're at the stage where a proposed settlement has been approved in principle, or at least a handshake in principle at the negotiation table. Now, once you have a proposed settlement at the negotiating table, the following occurs in terms of the process. Given the value of this particular claim, this claim has to go through a number of individuals in Ottawa in order for a formal offer of settlement to come forward to the First Nation, which, as Chief mentioned, we're hoping to receive in December of 2024 here, or hopefully sooner if we can. But the way the process works is after you have a negotiated settlement and the parties are prepared to bring that forward, Canada will then go and seek, and this is what Canada is currently doing right now, it is seeking a mandate to settle the claim. So what they do is they'll end up having to take the entire settlement and the studies that were commissioned and all of their internal briefing notes, and they have to get it through the minister's office and a committee first. And then secondly, it goes to cabinet, the prime minister and cabinet, for a formal mandate. Once that is obtained, the federal negotiator has indicated to us that they will be writing a letter, assuming that they can obtain their mandate from cabinet to settle this. They will provide back to the First Nation written correspondence indicating that they are prepared to settle the 1907 land claim on the basis of X dollars. And then they will be asking the First Nation to provide a band council resolution saying that they're in agreement with the settlement. And then the settlement can be taken to a ratification vote of the band members. Now, from now until we get a settlement, until you get confirmation, that a settlement offer has been approved by federal Prime Minister and Cabinet. We have a lot of work to do on the claim, as Chief Bowden has mentioned. There are 2 documents that have to be concluded as part of the claim. The first is a settlement agreement with His Majesty the King and the First Nation, and those are those aren't the those are fairly they're not overly complicated to do. You describe the claim, you describe what you're settling, you describe the ratification process. The ballot questions that'll be asked for the band members will be put in there as well. The schedule of the 1907 surrendered lands that were lost. So the settlement agreements, there's plenty of templates that Canada has that they've utilized with other surrenders in the last several years that they typically use to settle the settlement agreement. The trust agreement is the document that outlines how the compensation monies coming into the First Nation will be distributed and administered, and how they will be managed, going forward. And so that is the big document that will require a lot of work. And as Chief mentioned, it looks like you're looking at setting up a team to assist with legal counsel and putting together the trust agreement, because when the ratification vote is called, you have to have in place an initial settlement agreement and an initial trust agreement, and that's what the band members will be asked to vote on at that time. So a significant portion of our time in the months ahead, and this is good work. I always call this the positive work. After you get your, after you've got your approval in principle at your negotiating table, then comes the fun work of developing the trust agreement and doing it in such a way that it benefits the entire community, not only presently, but for future generations to come, and set it up in such a manner that, long after we're gone and our grandsons are gone, your grandchildren are gone, that there's still hopefully a settlement that the band members can be proud of and move forward on. So that in a nutshell is where we are. Dan, I don't know if you want to add anything further.
No, I only to say, this has been a long haul. Your First Nation, going back to the time of the surrender itself, based on oral histories that were taken for the Indian Claims Commission, it's clear that the stories of the elders go back to the time of the surrender, indicating that what happened on the day of the surrender was a travesty. According to your elders, it was a tie vote, and the tie vote was broken by somebody that had been brought in as a runner. That was part of the original history. There's support for that in a number of the documents. That was part of what we argued before the Claims Commission. But in addition to that, we also argued that there were technical reasons to say that there wouldn't have been a majority vote in any event because of the way you calculate majority. So we got into a lot of technical arguments, but the long and the short of it is, your band and your ancestors knew for a long, long time that what happened was not right. And as a result of that, the band lost some of its most valuable land at the time. And the reason they lost its most valuable land was because that's what the local settlers were after. They wanted that land. And they wanted it going back 20, 30 years before the surrender. And until Frank Oliver became the minister in charge in 1905, for the most part, you had the support of Indian Affairs to keep the wolves at bay. Once Frank Oliver got involved, unfortunately, the wolves took over in charge of the hen house, so to speak, or the fox. And your band and a lot of other bands during that 5 or 6 year period of his tenure were the big losers, because what he was after was your best lands, and he wanted them taken out of the reserve system. And he was largely successful in being able to do it. Successful, however, not in a legal sense. And it's been a long, tough battle to get recognition, which should have been given to you a long time ago. It was finally recognized in 2020 that what took place was not legal. And now, since 2020, we were able, with the assistance of some very good professional experts to put together a package that allowed us to negotiate what we believe is a very positive settlement. And we believe that when that offer is made in writing, provided, of course, it's the offer we expect, we believe that it will be a welcome one for your membership, and it will lead to a lot of future opportunities that will benefit the current membership and those that are yet to come. Unfortunately, some of the people that have passed on will not have shared in those benefits, but they certainly will be remembered for their steadfast contribution in making sure that this injustice was not overlooked. And so we're hoping in the coming months that we'll have a lot more information that can be shared with you. And we believe that you will find it to be positive, and we believe that there's a lot of light at the end of that tunnel, and we don't think it's a locomotive. We think it's good light. Thank you.
Thank you very much, Dan and Al. And just to, I want to give credit as well as appreciation to all of the hard work that Dan and Al have done. This has been not only hard work, but also hard work for them. And I want to acknowledge that work that they've done on behalf of our nation. So if we could give them a round of applause, please.
Thank you.
Next, before we go to the next part, we're opening up the floor for any questions to Dan and Al that any of our membership may have.
Just aside, we have 59 in person, 29 online, just about 90. What was the question?
Hello. I was just inquiring about the land value in the last couple of years has gone up quite a bit. Like a few years ago when we sold our farm, a quarter of land was selling for 70,000, and now today they're selling between 400 and 600,000. Are we negotiating that kind of figure in the quarters of land or acreage?
Just before legal counsel speaks, I just want to say that especially Councillor Terry has been very adamant about exactly what you're talking about. And unfortunately, I don't know if Councillor Terry wants to speak to it a little bit, but that's been when we talk about some of those hard decisions and taking that hard look at exactly where we're at today and how that factors in even within the negotiating time, that there's had to be some give and take within there.
Okay, yeah, thank you. That's a good question. I'm somewhat prepared to answer it, maybe not to the full extent, but I'll go back to TLE in 1996 when we first started buying land. I think we were paying around $300 to $400 an acre, right?
Yep. When we started out, it's good. It's good. The max was 262, but we were paying a lot less than that. We paid a lot less. So I think the average quarter we would have paid was about 40,000 a quarter.
Yeah,
The highest one would have been about 80. The lowest one was really about 20. And we bought most of the land at that price.
But you also got to remember that at the time, we bought a lot of land bought by Cowessess First Nation. The trustees was the poorest land available. It wasn't a good economic decision to buy that land at this time. So now if we went out to buy the best land or the quality of land that we lost south of Cowessess First Nation, all of Township 17, that would be some of the most expensive land in the province. And your numbers are right. Now the average price per acre of the land is around $3,000 per acre. So you see how much it went up from $285, $250 an acre to $3,000 an acre. We got to be very diligent in what we buy here. If we tried to replace all our land that we lost at $3,000 an acre, we would never do it, and Canada would never give us the funding to do it. We got to be diligent, we got to be smart, and we got to be innovative on what we buy and what we buy it for. Like business plans for every bit of land we buy, that's going to be very important. Not just buy land for the sake of buying land now and not being able to rent it out. The rental rates in Saskatchewan right now of farmland is anywhere between 2.5% and 5.8% of the value of an acre of land. So depending on where you're at and the number of farmers around that want your land, if you paid $3,000 an acre of land, you could ask anywhere from 2.5 to 5.8% of rent per year. Now, I did numbers on that, and we're still a bit under on what we should be getting. But we went from 1.3% to about 2.25% now. We brought our rental rates up. We're not where we should be, but we're doggone close. And I'd say within 2 or 3 years, within 2 years, maybe next year, we'll be up there. I got a plan to open up the competition a little bit more, and we'll get there. But to answer your question, no, the value of land increased, and we're aware of that. Okay, thank you.
I can add a little bit more if you'd like.
Go ahead.
Can you hear me? Okay.
Couple questions. One of them being, is it one vote when it comes to the trust agreement and what we're accepting? Or can it be 2 separate votes?
No, it's I can answer that. It's one ballot, Gary. It's one ballot question. So the band members, as part of any of the specific claim settlements, it'll be a 2-part question, and members will have to check yes or no. But basically, the ballot will read, as a band member of Cowessess, do you approve of, number 1, the settlement agreement, and number 2, the trust agreement, and do you authorize the chief and council of the First Nation to execute both agreements? And so that's why, when you take the vote, when you conduct the ratification vote, the band members will be asked to vote on the 2 documents, the 2 primary documents being the settlement agreement and the trust agreement. So it's important that we, in the months ahead, before we get the offer formally, that we begin the work on developing the trust agreement and making sure that that trust agreement meets to the satisfaction of your membership and to your leadership, and contains all of the things in for wealth generation, wealth creation in the future. Thanks.
A short time for a big document.
Yeah, it is, yeah.
One more question.
Sure.
Doesn't do you justice up there on the wall when it comes to presenting another meeting, which I'm going to be asking for on reserve regarding 1907 and agricultural. Would you attend in person?
Mm-hmm. Oh, for sure. If you'd wish us to attend, like Dan, yeah, sure. Yeah, we'd be more than happy to attend in person and answer any questions you may have. Yeah, for sure.
It's kind of surprising you're not here. Because
It's not their fault. It was my request, Bubsy.
okay, cool. No, like I say, surprising because you get a lot more than somebody on the wall like this.
I'll talk with you about it after we're done.
Well, that's a request.
There was a very specific reason, and I'll share with you after.
There's another one.
You talk about agriculture and what exactly, I have a few more questions. What exactly do you mean by agriculture? Like people farming the land and everything? Because all that equipment is super expensive nowadays. So what exactly do you mean by agriculture?
Yeah, in my opinion, agriculture is anything we use for food production, and that could be anywhere from raising honeybees to raising beef, cows, or bison. That's all agriculture. Anything in between, growing anything that's live, and by anything live, I mean plants, vegetables, grains, oil seeds. That's agriculture, and not necessarily farming the land like a farmer, like what I am, and buying that expensive equipment. There's many forms of agriculture, and this is not the time or place, but next week, I think we have another meeting coming up on 4C and lands. And I believe that's where we'll take some more in-depth questions on that.
So you talk about the ratification vote now. Are you going to be getting membership input on what should be included in there? Because I do recall when we had the TLE one, we had a meeting and then the membership wanted changes in there, but things were never changed really in it. So I think there should be membership input into what goes, especially regarding the payout, the amount of land, how much money you're going to save for umpteen 7 generations.
That's not for legal, that's a chief and council question. We are the ones who decide and not legal. And so legal will be part of the process, process. Like we had discussed a little bit earlier, that as we put together the trust agreement, that it will be with our membership, it will be with staff as well as a whole consultation process. So it won't be sitting with legal. We will be directing legal on how to put together the trust agreement. And membership will definitely have a huge say in that.
A huge say into what the payout's going to be.
Into, yes, what the options are, because I mean, there's going to have to, like, we'll be looking at the impact of basically 4,500 members with what the payout is, potential other claims, which we'll be talking about later on. But the fact of setting up that wealth creation strategy for the upcoming generations.
And do you know how much more land we have to buy?
In the TLE?
Well, mentioned in the 1907 that you guys are going to buy more land or something, or did I miss it?
Al, I don't
Yeah.
know if that is confidential as of still yet.
No, not the number is confidential, but as part of the settlement, ladies and gentlemen, the First Nation in 1907 lost 20,704 acres. So in the settlement agreement, there will be provisions that would allow the Cowessess First Nation to go out and purchase anywhere in Saskatchewan, the province of Saskatchewan, an additional 20,704 acres of land, and to have that land added back to the reserve. They will be given that option, like they were given the ability to put land in under TLE, under the specific claim process and the surrender claim. You're to be put back in the position you were had the surrender not taken place. So had the surrender not taken place, Cowessess would have enjoyed 27,704 acres. So 20,704 acres. So we'll be given the ability to go out as part of your trust agreement, part of your settlement, and go out and put that amount of acres into reserve status if you so wish. Thanks.
So we do have to buy that 20? No, we don't. Okay, so
You will have the you'll have the option to go out and buy it if you wish, and to put it into reserve status up to 20,704 acres.
Well, and also
That's
we will be allowed to utilize the amount of acres that are left over with the TLE as well, and utilize, which Al is about how much?
I think you've got, according to Loretta's last calculations, I believe we've got just over 100,000 acres that you still left to buy. There's money still in the TLE count, but there's still the equity acres for Cowessess, I think is over 100,000 acres left to buy. So when you add the two together, ladies and gentlemen, if you decide to recapitalize or go up to the full equity acreage in the TLE, together with the 20,000 acres, you could potentially purchase, if you wish, in the years ahead, up to an additional 120,000 acres land.
Okay, good ones, Pat. Here.
And like Councillor Terry had said, that we will be looking that for any other lands purchase, there's sound business plans behind them, and there's purpose for all land that's being bought. It's not going out and buying lands just for the purpose of buying lands. So we're going to be very strategic in any lands for ATR in the future. Dodie?
Hi, Al. I have just a couple of questions with regard to land purchase. At last week's Nation Talks, part of our economic development concerns were the fact that it's taking considerably longer than was originally estimated or idealized to actually convert our TLE lands to reserve status. And that extra burden of cost, in other words, the property taxes and the all sorts of service agreements we would have with RMs and municipalities, that those costs we are now bearing the burden of because we simply are not in a space with the Crown to effectively transfer that land to reserve status. And that seems to be a bone of contention that we are having to take care of right now as current membership. And I know that with the flood claim agreement, there was an expedited process for the conversion of our lands to reserve status, but only up to a certain percentage of that could be utilized, and our TLE lands could be utilized in that process. With regard to this settlement and this specific claim, have you considered that as well in your consultations with the Crown? In other words, the fact that it will probably take us considerably longer to convert any land purchased under the specific claim to reserve status. Has that been a conversation at the table?
Yeah, no, great question. When it comes, okay, so there's two types of claims and they both have their own separate processes. So the TLE settlement is driven by the settlement agreement, which is based on the 1992 TLE framework agreement in Saskatchewan. So all of the provisions regarding putting quarter sections or urban lands, urban reserves into reserve status under the TLE side is governed by that process. And that process, so under TLE, for example, if we go buy land inside the boundaries of Regina, Yorkton, Prince Albert, whatever, an urban municipality, we've got to negotiate a number of agreements under, I think it's Article 8 or Article 9 of the TLE settlement agreement. We've got to negotiate a municipal services agreement for water, sewer, infrastructure. We got to negotiate a police services agreement and an education tax loss agreement with the school boards. Now, that's different than a surrender claim. A surrender claim, such as the 1907, like the flood claim, will be governed by Canada's additions to reserve policy. So it's much easier to put lands into reserve status, a little easier, for example, an urban setting. I'll use the example of an urban setting because the delineation is clearly different. So under a surrender claim, so under the 1907 claim or under the flood claim, we have the ability to put into reserve status up to 40 acres if we go urban. But under the 1907, we'll have 20,704 acres. We can buy that land anywhere in the province of Saskatchewan. So, but I'll use urban, for example. Under a surrender claim, when you go to buy lands in the city of Regina, Yorkton, or wherever again, if we buy land under the 1907 land surrender claim and we put it into reserve status under the 1907 claim, it's much easier in the cities because there is one agreement that we do not have to negotiate, and that's the education tax loss agreement with the two school boards. So to put lands into reserve status under a specific land settlement like a surrender is much easier in an urban setting because the only two agreements that we have to negotiate, ladies and gentlemen, are the municipal services agreement and the Board of Police Commissioners agreement, or if it's patrolled by the RCMP, just one agreement like in Melville, Yorkton. So I hope that, so yeah, it is quite easier to put lands into reserve status, especially in an urban context, under a specific claim versus a TLE claim. But yeah, so we will have the opportunity to do both moving forward, but one is considerably easier when it comes to one particular portion of land. Thanks.
Okay, thank you. And then the follow-up question to that is, if we're going to go ahead and purchase more land, the one thing that I like to consider as an environmental person is environmental reclamations that may have to occur under any lands that we purchase. For example, we buy land here in Regina and we find out that 50 years ago there was a gas station there and that the tanks are still underground and the cleanup remediation has to occur. In those kind of cases, if we were to purchase that land, do we have processes that will ensure that we do the best we can prior to purchase to ensure any discovery of environmental reclamation needs to occur? And if we don't, what is our culpability afterwards should we discover something like that?
Yeah, when you go to look at doing that, you should, like in the context, you do have the option Yeah, and you will have the option under both settlements, TLE and spec claims, to do environmental site assessments, phase 1 or phase 2 assessments on properties before you buy them, and you can also do any other due diligence that you have before you buy the lands. Yes, you have that. You'll have that ability to do that, and under Canada's ATR policy, especially when it comes to urban reserve creation, they'll actually require those steps be taken in any event. Yeah.
And for everybody, ATR is additions to reserve.
Yeah.
For those that aren't up on the TLE and lands lingo.
Okay, I think there's a pretty good scan they have with the federal government. It's called ATR. What is that process called?
Additions to reserve. is
Okay,
what-
yes. So when they're looking at the land, there's a process they have to go through and look at all of that. And I believe you have to fill out a checklist, don't you, in order to cover all of that?
Yeah.
Information Services Canada. Yeah, that's right. Yep. Okay.
So I guess just to wrap this up, if we can, bottom line, what members want to know. Where is it the 1907 at? What is the timeline? Well, do we have it in? Are we going to really get it in this lifetime because others have not seen it in their lifetimes? What is the timeline to that? What is the process for us to be able to benefit? And is there opportunity for us to contribute to what the benefit to the individual's collective are? So the answer to the first one, and Al and Dan, please correct me as I'm trying to bottom line this for the crowd, is that the 1907 is as close as it's ever gotten to being completed. We are just at the final stages informally as a claim could possibly be, whereas we've come to an agreement informally in principle that is now going through the processes of Canada. And we don't have any control. Even the minister himself does not have any control because there's different ministers in control and take different parts of that. We have been told 12 to 18 months timeline. So that's what we're looking at. At that time, in the meantime, we are looking at 2 different processes that we have to put together. And that's the settlement trust. Sorry, I was just reading it here and my mind is not as good as it is usually. The settlement agreement and the trust agreement. Now, the settlement agreement is more technical from our perspective, but it is the trust agreement that we will be going out and putting together a task force, putting together a team of people in order to put those options together for individual and collective benefit in payouts. So those are the bottom lines of the questions that we've heard today. Does that pretty much cover it?
Yes. I think that's the essential ones. We can't do any more because we're not at the end of a deal yet. Those are the important ones. But the second one, I think you're right. Something to look forward to, how we're going to get involved in it. That's what you're saying?
Yes.
That was what Patrina was asking.
It won't be just that all of a sudden we're asking for people to submit their phone numbers and their addresses and trying to send out a package. We will be informing people throughout and having membership meetings throughout the entire process as well.
Threshold. Can you tell us the threshold for a vote, lawyer?
Yes, it will, given the potential value of this claim, and this will be part of the settlement agreement. What was the threshold again?
I missed the question.
So it was the
Threshold
for the
for vote, for the vote. How many people?
A majority of a majority.
Yep.
Majority of a majority?
You need a majority quorum. So in other words, whatever number of voting members are eligible to vote, you need at least 50% plus 1 to vote. And that makes a quorum. And then of those that vote, you need 50% plus 1. Now, if you get the second majority, in other words, a majority of those that vote, but not enough to make the first quorum requirement. Let's say only a third of the total members vote, but of that third, 90% say yes. That's a situation where you would have to call a second vote because you haven't met the quorum. In the second vote, there'd be a revised quorum, and the revision to that, because of the size of this, is likely to be a 25% quorum instead of a 50% plus one.
Yeah. So just to use practical terms, ladies and gentlemen, just say hypothetically, we've got, at the time of the ratification vote, you've got a voting population. I'll just use the figure of 4,000 band members over the age of 18 as of the date of the ratification, the final ratification vote on the reserve. We would need 2,001 to vote, and of those, 1,001 to say yes. So 50, it's a majority of a majority on the first vote. If we don't reach that quorum, they'll still open the ballots, and if a majority participated, were in favor, the First Nation would typically have the ability to call a second vote, but they would have to achieve a minimum quorum of 25% of your membership, which would be 1,000. Yeah, 1,000 voting only.
Yeah.
So I hope that answers that question, Terry.
Yes, thank you very much. So once again, thank you for your time today, and we'll be talking soon. And have a wonderful rest of your Sunday.
Yep. Thanks, everyone, and
Thanks.
all the best membership, and take care.
Everybody, a round of applause for our.
Thank you. Appreciate it.
Bye for now.
Okay, so we'll do a quick 5-minute break and then carry on with the second part of our session.
All right, everybody's getting back in here. We'll assemble ourselves right away. And just before the chief gets on here, those reports you're looking at, they tell our story about from 1990 about, 1880 till about 1907. It's about our own families, and we're trying to put it together in one document. There's about 4, 5, 6, and there's another one coming, another research report about us, about all of our relatives before. And the ones that they're doing now are they're still confidential, but it shows how much, shows how much, how big of our gardens were, how much we grew, who grew it. Tells you how much horses you had, how much cows we had in a particular year. And once we can get all of that stuff, it's all over the place. And I had 14 pages of bibliography recording that. So we'll try put it in one document, maybe a video, and it's a big sort of a big project that you just can't write a book about it. But anyway, we'll start on it now. I'll let the chief take over on the cows and plows. Thank you very much.
Thank you very much. Everybody who wants cows and plows. This has been probably the hot topic, and this is actually once again, I'll stand away from people and I'll put this down. This has been the topic that has been of highest consideration for us, not only the ag bends, which is the cows and plows, I guess known as cows and plows, but also other indexing annuity types of payments where people have, there's one class action on annuities, which is by Chief Lynn and Chief Lynn from Zagame and Chief Derek out of Neepanak, out of what's his First Nation? Oh, pardon me? Pine Creek. And so they have one, and a class action suit is different than the spec claims process. Like I had said, right now, in an effort for us to look at the best interests of Cowessess, we're putting together different ways to ensure that Cowessess membership get the best bang for our buck as well as our knowledge. And so we're putting forth different types of procurement policies to ensure that the goods and services that we receive, regardless what they are, of a maximum benefit to Cowessess. And in one of those areas is legal services. And so in the area of legal services, right now we're in a procurement process where we are inviting letters of interest to law firms who would like to put forth in order to represent Cowessess. And I think that I do have as part of the, if we could go to the next slide, Corey. There's two. But there's two, if you can see. So in the meantime of us going through that procurement process, which includes all aspects of our band in terms of legal costs and fees, that was one of the main reasons why Brabant and Company, as well as Madison Twos, they are the two legal firms that are representing Cowessess on the 1907. And because we're in such a far along that deliberation process, we've continued with that there. However, with all other of our legal processes, we are out for procurement. And that's one of the reasons why for the Ag Bends update, because if the people choose, if we are told to move forward on cows and plows or Ag Bends, then what we will be doing is going out for procurement on accessing legal services for that as well. So in the meantime, in order to get the information out, we've asked Dr. Jamie Benson, who is not a lawyer, in order to discuss the whole concept and the whole process of agriculture bends, as well as some of the indexing. Jamie, Dr. Jamie, are you on?
Yeah, I'm here, Chief. Sorry, I was just getting unmuted. I'm not actually a doctor, but I'll take the promotion.
Why did okay, there you go. Why did somebody, Jamie and I have known each other for many, many years, since the early days, early 2000s of FSIN. But Jamie, other people don't have the luxury of knowing the incredible background that you have in this area. So could you introduce yourself and some of your credentials, please?
Hi, good everybody. It's a pleasure to be here and meet with Cowessess. It's actually interesting because, as the chief said, I've been doing this a long time. I actually started back in 1994 with the Office of the Treaty Commissioner at the time. And one of the first claims I actually worked with was the Cowessess Treaty Land Entitlement TLE claim. So I actually started out doing some of the pay list research about who would be counted for land entitlement with Cowessess and then with other First Nations. Then I worked for the Office of the Treaty Commissioner till about 1998 when I joined the FSIN, and I worked there for a number of years. I've been involved in all kinds of claims settlements and claims negotiations and doing research. And for the last couple of years, I've been working independently as a consultant. So I've done a lot of work in Saskatchewan related to specific claims. I'm also a special advisor to the AFN on specific claims reform and national claims issues. So that's kind of my background, and I'm pretty familiar with Cowessess. I've done research, as I said, on the TLE, and even have done some on some of your other claims like the 1907 and agricultural benefits and other kind of claims in not just with Cowessess, but all throughout Saskatchewan, Treaty 4, Treaty 6, Treaty 8, as well as Treaty 10. So it's a pleasure to be here, and I look forward to a good discussion today. Thanks.
Thanks, Jamie. Corey, if we could put up the slideshow, and Jamie, you're able to see the slideshow as it's presented, right?
I can't see it right now, but when it's up, I usually can, yeah.
Okay, are you able to see it now?
No.
Okay, just give Corey a second, he said. And if you could go through the slides that we have up and then be able to answer any questions after that.
Sounds good. Oh, there we go. Okay, the slides are up. So I'm just going to go through some slides which were prepared by Corey and myself. So just a little bit of background about agricultural benefits and treaty. So the treaties actually, there were treaties that preceded Confederation. So in pre-Confederation treaties, they started out in the early 1800s, and they were just essentially like land transactions where land was surrendered in for a single cash payment. It was around about the 1820s when they started introducing the concept of treaty annuities, which were a payment year by year by year. Instead of just one cash payment up front, it was a payment over that time. But the treaties became more and more complex as time went on. In 1850, there were what was negotiated were called the Robson Treaties. So there were two treaties, the Robson-Huron and Robson-Superior Treaty. And for the first time, they expanded the benefits which were provided under treaties. So there were three main promises in the Robson Treaty. One was a promise of land for farming. The second was a promise of protection of hunting and fishing rights. And the third was the annual payment or annuities. That model was what, when post-Confederation, when the government of Canada decided, or the Crown decided, they wanted to make treaties with the First Nations out west, the initial idea was that those three provisions would form the basis of all future treaties. However, once they actually got out into treaty negotiations, and the first two number treaties were in Manitoba, Treaties 1 and Treaty 2, the Ojibwa who negotiated the treaties said that those provisions weren't sufficient. They asked for additional promises. They asked for schools to educate their children. And one of the other promises they asked for was assistance to start farming. So they asked for certain package of implements and livestock. This was not actually included in the treaty text of Treaty 1 and 2, because when the lieutenant governor who negotiated the treaty, a fellow called Archibald, came out, he had actually a pre-prepared treaty, so it didn't have those provisions in it. But what he did was he made a list of what he called outside promises, which included these other provisions like farming assistance, education, but they weren't actually in the treaty text. So when the treaty gets sent back to Ottawa, they just look at the text. But the First Nations said, hey, wait a minute, we were given all these other promises, where are they? So what the government did eventually, actually a couple of years, was take the list of these outside promises and incorporate them into part of the treaty. But these promises would be expanded in future treaties and became really the basis of the numbered treaties, so that when Canada went out to negotiate the third of these treaties called Treaty Number 3, which is in an area in Ontario going into Manitoba, the promises, the treaty First Nations proved to be really good negotiators, and so they were able to get more and more promises under each treaty. The package of implements and livestock was expanded to. There was the promise of education. There was a promise of ammunition and twine to assist with hunting and fishing. And eventually there would be also promises in Treaty 6 of medical assistance. So these promises were incorporated into Treaty Number 4, which Cowessess is a signature to. All the numbered treaties subsequent to all the numbered treaties except for Treaty 9 contain promises of assistance to start farming. You can go to the next slide. So these treaty promises, agricultural implements and livestock, were not a promise to individuals. They were promised to the collective. So, you know, there was so many cows, so many ox, so many plows, so many hoes, all the implements which were supposed to be used by the First Nation to develop what was an intergenerational farming economy. So, there was land for farming based on the treaty formula of 128 acres per person, or 640 acres, and to allow the First Nations to develop that farming economy, there was this package of agricultural implements. And you have to realize at the time, 1874, it was a fairly tumultuous time on the prairies. The Northwest Mounted Police were sent out the same year from out east to quell trouble at the border between the Americans and the Canadian government. A lot of the First Nation people at the time were congregated around Fort Walsh in the Cypress Hills. These promises were meant to allow the First Nations to develop an economy. So the buffalo was disappearing. There was a need to develop an economy. And at the time, the main economy that people were engaging in the West was agriculture. So with that, the treaties made promises. I mean, they had specific items: 2 spades per family, 1 plow per 3 families, 1 harrow for every 3 families. The implements also include certain amounts of livestock per the number of families, a school to teach agriculture and farming, as well as a teacher at the school to deliver agricultural education. These promises at the time were not considered annuities. There were promises of annuities. You got, you know, the $5 was an annuity. Even the ammunition and twine promise was year after year. So that as well was annuity. The promise for agricultural benefits was this package would be provided that would allow the First Nations to develop an intergenerational sustainable farming economy, and that farming economy would keep going for generation after generation after generation. The problem was they didn't provide the assistance that was promised under treaty. So next slide, please. So as the slide said, these provisions were replacing the traditional economy with the economy of the newcomers. So it was agriculture. This was an incredibly important treaty provision and must be understood how large of an issue this was and still is. An economy determines the very health of a nation, and we're being asked to replace ours in its entirety. This settlement is often, you'll hear the term, it's colloquially known as cows and plows, but it's agricultural benefits, farming assistance, whatever it's called. Those were the promises under the numbered treaties. The problem was, as I said, that the government, I haven't actually seen a single case in Treaty 4 or Treaty 6 or Treaty 8 or Treaty 10 for that matter, where all the implements that were promised were provided. So in some cases, there was a partial fulfillment. They provided some items, but not all. And in some cases, it was not just a question that they didn't provide the proper quantity or proper number of implements. It was also the quality. If you had a plow that broke, or it was cheap, or you know, implements that would break, that's not fulfilling the treaty promises. Or if you, you know, provide livestock that's old or starving or not healthy, that's not fulfilling the treaty promise. So in all the research that I've seen, in all the cases I've seen in treaty, the implements and livestock were not provided to allow the First Nation to develop that economy. Next slide, please. Of course, the fact that they didn't provide these implements and farming assistance was compounded by the fact that they also didn't, you know, provide the land that they were supposed to. There were other treaty promises as well that they didn't fulfill. There were promises that they were supposed to provide assistance in times of difficulty, hardship. We all know the number of treaty promises that were broken. and that land and farming implements went together. So the land was unlawfully acquired, and therefore the implements and benefit were not delivered as promised in the treaties. While Canada did deliver some implements and benefits in the beginning to certain bands, it was found that it breached its lawful and fiduciary obligations and subsequently opened the agricultural benefit claims up for settlement under the specific claims policy framework. Next slide, please. So under the specific claims policy, First Nations and I actually worked on the development of what's called the Specific Claims Tribunal Act, which was created in 2007. So I'm pretty familiar with the policy and the framework under which the specific claims process operates. So normally what happens is a First Nation files a claim, Canada does an assessment of the claim, they determine whether they're going to negotiate the claim. If they say, yes, we breached our lawful obligation. If they say no, then a First Nation has the option of going to the tribunal, which is essentially a court which can make a binding decision on both sort of on whether Canada breached its lawful obligation as well as compensation. In the case of agricultural benefits, however, I was part of a mediation process with another Treaty 4 First Nation and a Treaty 6 First Nation with an ex-Supreme Court Justice, fellow called Frank Iacobucci. And we developed out of that a framework approach that could be applied to the settlement of agricultural benefit claims. First Nations under this process can opt into that process as an expedited way to settle their claims, but there's no requirement that a First Nation who files an agricultural benefit claim settles on that basis. That's one option as an expedited process. And as part of that, if a settlement is reached, it will be for an amount of compensation, but how the terms of that settlement are set out in what's called a settlement agreement. And under that settlement agreement, there'll be certain provisions. There'll be indemnity clauses, there'll be release clauses. And what an indemnity clause does is it means that Canada is going to provide compensation for a breach of a lawful obligation, which in this case is their failure to provide agricultural benefits or cows and plows. And that in return for compensation, Canada will ask that the First Nation agree that you won't sue them for the same claim. So you can't get compensation for a claim and then go to court asking for additional compensation for the same claim. It will be negotiated settlement so that there will be what's called then a release clause as part of that. And that defines exactly what Canada will release in return for that compensation. And in the case of agricultural benefits, as part of the negotiations, if you do decide to file a claim, the settlement agreement will be part of those negotiations. It will be negotiated by your lawyer, your advisors, your negotiating team, and it will contain the provisions that you're agreeing to. It's very imperative and to be very cautious with the release clause, because that's what releases Canada from future obligations. In the case of agricultural benefit, the release clause should only release Canada from the failure to provide agricultural assistance. It should not release Canada from other treaty provisions. There should be no mention of things like health, education. There should be no provision that impacts lands or other treaty rights. The release should be confined to what Canada is paying compensation for. In this case, that would be for the failure to provide agricultural benefits. There also can be negotiated into settlement agreements what are called non-derogation clause. And a non-derogation clause is a clause that states that nothing in this agreement will abrogate or derogate, which means take away or reduce treaty rights or any other indigenous or aboriginal or section 35 rights. So under your settlement agreement, it's very important that you know, your experts, your lawyers, your consultants, make sure that what's being released or given up in return for compensation does not impact other treaty rights, that no treaty rights should be eroded. In fact, changing any part of the treaty is really actually impossible or difficult to do. Treaties are protected under the Constitution, under Section 35. They're, you know, nation-to-nation agreements. So the Crown does not in any way, by settling these claims, get out from any other treaty right or treaty obligation. Next slide, please. So I guess the question then is, where are we today? So there really are, I know I was talking to the chief yesterday, and we had a really good conversation in terms of, you know, I know Cowessess hasn't filed a specific claim yet in relation to agricultural benefits, and you're giving consideration within your community to whether you should or should not do so. So there's some different options to consider. One of them is to file a specific claim alleging that Canada breached its lawful obligation by failing to fulfill its treaty promise to provide agricultural assistance. So filing a claim does not bind the First Nation to any particular type of settlement or any settlement at all. All it means is you filed a claim with Canada saying they broke their own law. They have to come to the table and negotiate a settlement for that. There is the option as part of the agricultural benefits. There's a cabinet mandate for this expedited process based on a framework that was developed as part of the mediation with Mr. Yakabuchi. You can opt into that. There's no requirement to do so. Even if you file a claim, you could try to negotiate on a different basis. That's certainly an option. If Canada comes back and says, no, we won't negotiate, then you have the option of filing with the Claims Tribunal and having a judge make a determination, both whether Canada broke its law and to what the compensation will be. So one option is to go through or file a claim through the specific claims process. A second option, which is always available, sorry, my dog's nose is in the way here, is to file a statement of claim in federal court. So that is always an option with these types of claims, because if Canada broke the law, you can go through the courts. There are some hurdles, though, in terms of going through the courts. One is the time and cost. The court process can be really costly and take a long time to resolve. It's also, there's no guarantee, and there are things like technical defenses that the Crown may argue, which is, you know, you waited too long to file your claim. It's called statutes of limitations. And unfortunately, there was just a recent court decision about a week or two ago called Jim Shot Both Sides, where the Supreme Court upheld the application of provincial limitation periods to treaty claims and Aboriginal claims or Indigenous claims, which was unfortunate, but it was what the court decided. And of course, the other option is just to not file a claim, you know, wait for another process or wait for things to develop. So there are certainly different options that Cowessess can pursue. And also, it's possible that the options are not necessarily mutually exclusive. It is possible to file a specific claim and a statement of claim in court. As part of the specific claims process, you would be asked to put the court action in abeyance pending resolution through the claims process. But by filing a claim in court, you do preserve any argument that you waited too long or that you're out of time, because as soon as you file, the clock stops in terms of you know, any limitation issues being applied to your claims. So those are kind of your options. Next slide, please. So just in terms of, I guess, previous chief and council made the decision not to pursue an agricultural benefits claim until after the 1907 land surrender claim is finished. And I understand you're fairly far along in that process. There's also an opportunity now to go through the expedited process that I talked about. And there are other considerations as well. I mean, I think we all know, you know, when the next federal election is coming up. There's a mandatory election in November of 2025. The government is a minority government, so it's quite possible that, you know, it could be an election even before then. If there's a change in government and we have a conservative government, I was there during the Harper years, and basically they weren't settling anything. Their sort of approach was, you know, even if we broke the law, even if we're wrong, you don't like it, take us to court, and we're not going to pay until a judge forces us to or tells us we have to. So there is that consideration to keep in mind as well. So a lot of First Nations are trying to get their claims through and resolved and negotiated before the next government comes into place. So next slide. I don't know if we want to just stop there and maybe see if there's any other questions. There are a couple of other claims that I know the chief referred to, which are potential specific claims which could be filed. One is a claim for indexing of treaty annuities. So the $5 at the time of treaty, and I've done a lot of research into this, and you look back through the treaty documents, and the First Nation negotiators, Treaty 4, Treaty 1, Treaty 2, Treaty 3, they all asked why $5. And what they were told by the commissioners was that $5 for a family of 4 or 5 was enough to provide groceries or supplies for the winter. So a treaty annuity had real value at one time, but over time, inflation has reduced that $5 to almost a symbolic payment. I mean, you know, the difference between a family of 4 or 5 being able to buy groceries and $5, what does it buy you today? Maybe a chocolate bar, maybe a chocolate bar in a pop, maybe not. Certainly the value of that $5 has been reduced. There is negotiation mandate in another treaty area to solve treaty annuity claims, and I've been working on it with a couple of First Nations, Saskatchewan First Nations, on that. There's also been a class action initiated in Treaty 4 by Zagame, Chief Lynn Akus, and Chief Daryl Nepanak of Pine Creek. So there's the option of the class action and joining that. There's also an option to file a specific claim, which is something personally I would recommend. And maybe if that's something Cowessess is interested in, consider sort of both options. There's other claims as well. I suspect research would show that Cowessess's trust fund money was mismanaged, and there was quite a bit of money in the trust funds for the 1907 surrender. Every time I've seen a large amount of money in the trust funds, there was illegal activity and mismanagement by the government. So that's certainly a claim that could be researched. It's not part of the 1907 surrender. It's compensation for a different claim, but it's certainly something that could be looked at, as well as claims that veterans should have gotten land off the reserve, not been provided land on. You know, there's also a component of First Nations losing land that was should have been given to individual veterans as opposed to taking out of the First Nation. So those are some of the other claims as well that I think Cowessess may want to research and file in the future. Next slide, please.
For the other claims, there's also the mismanagement of funds by the Indian agent as well as the twine and the head person salaries clothing and salaries. Are those three others that others are looking at as well?
Yeah, exactly. Well, I think the mismanagement of the Indian agent would be part of that trust fund mismanagement. So it would be looking at the mismanagement of all the funds. There's also claims that the ammunition and twine component could be indexed. The salaries for chief and headman, which was under Treaty 4, I think $15 for headman, $25 per year for chief, and as well as the triennial clothing. The negotiations I've seen in other treaty areas have combined the three indexing components into one treaty annuity indexing claim. So it would be the negotiate the $5 plus the salaries, plus the clothing, plus the ammunition and twine into one potential global settlement. So they could be filed as separate claims, but negotiated as a global package.
Could you explain a little bit more about the indexing of the $5? And I'll just preface it by, first of all, when I was speaking with Chief Lynn, she had said that the reason why they decided to go with a class action is that a class action would have every member receive the compensation themselves. If they receive a settlement. And then secondly to that, there could be the inflation if in the decision, not only would individual members receive that amount, but also in the decision that it would state from here on in inflation and the costs of inflation within that. And that might be a little bit different, or it may not be, with First Nations that do it as a collective under the specific claim.
Yeah, so there's there's several components to indexing claims. So the way the compensation would likely work and how it's working in other treaty areas is there will be compensation for individuals who are alive today, likely based on their date of birth. So people who are older would get more money because they would have been more years where they didn't have their $5 indexed. There should also be compensation for individual members who passed away. So going right back to 1874, those individuals should also or the First Nation should also receive compensation for the people that have passed away, plus the ammunition and twine component, the salaries. So there could be a component of a settlement of indexing that goes to the First Nation, and there could be a component that goes to individuals based on date of birth. So that's kind of issues that will be addressed as part of the compensation, but that'll only be compensation for the historical. There'll also have to be negotiations about what annuities look like going forward. And Canada said they're open to different ideas. So it may not necessarily just be taking $5 and adjusting it for inflation. It may be tying it to resources or sort of other components. And those could be a component of future negotiations.
There was a question about, is there any impact with Bill C-31?
Well, the Bill C-31s and there's subsequent amendments to the Indian Act after Bill C-31. Those individuals would all be counted as part of modern population, and there would be compensation for them when they receive or when they're brought into treaty for their treaty annuities. So Bill C-31s, anybody that's a band member should be compensated or be included as part of these formulas. So the compensation really shouldn't distinguish between Bill C-31s and other band members. Everybody should be treated exactly the same.
There's a question, but it's for you. And once this guy is done, we can deal with those questions. Okay, whenever he's done his technical stuff.
Next slide, I think he had asked for. Okay, so I guess this is the question that we have for there's questions that we could put forth to Jamie, but also from our perspective as your chief and council is, does our membership wish for our chief and council to pursue a submission for the ag bends as well as other indexing claims as soon as possible?
Correct.
Remember what Jamie had said was that a submission does not mean that we accept. It's just putting us into the queue is really what it's doing. And then secondly, if so, we will continue with the procurement process for the best legal firm with benefits back to Cowessess, including specialization in the area, giving back to our nation, reasonable costs for the legal services, and the most up-to-date legal knowledge in the different areas.
The question that come online was, I guess, related to that. Where do we get the money to sue the government? We have to pay lawyers and stuff.
Do you want me to take a run at that, Chief?
Sure, Jamie, thanks. I was just trying to think about all the different layers to that, but if you want to, go ahead.
Well, I can. So there is some funding available for the government if you go through the specific claims process. So there's funding available for the research and development of claims. So to put the claim together, you can put in an application for research funding. Once a claim is accepted for negotiation, there's also funding available for the negotiations. If you go to the tribunal, there's also funding available there. Likely, though, the funding is insufficient to cover all the costs, but it is possible as part of the negotiation to negotiate a top up to cover any additional costs. I know in the First Nations I'm working with, we've been able to negotiate so that in terms of the agricultural benefit claims, all of the costs are paid by Canada. So if your settlement is, I'll just throw out a number, $100 million, you want to put in costs for a certain percentage to top that up and put that as part of the claim settlement amount. So.
Okay, and also we have, once Canada had accepted the claim for the 1907, we have been receiving on a yearly work plan, we've been receiving compensation already that that both Brabant and Company as well as Madison Twos have received the compensation that we've received from government, as well as the fact that Canada has paid for the and we have paid through the money we've received from Canada, the reports that Al was talking about. So those are jointly owned by Cowessess as well as Canada, because those were paid for through that compensation process that Jamie was talking about. For some of those other areas, it would be exactly as Jamie said, that there is money for us to put those together. Now, in regards to the ag bends or the cows and plows, Canada has already indicated to us that they are willing to consider our submission for that agricultural benefits amount, and that we would just need to submit a BCR and a letter of intent, and then to move along that process with our 1907. So we don't have much work to do. Much of the work has already been done.
You're asking us to, that's the first
Yes.
question? Okay.
The only question.
Okay,
That's
she's
the only
asked-
question for tonight.
Okay, should we go forward with it? Is that
Yes.
what you're saying?
Yes. Do we, what are people thinking? I'm not trying to put it all on everybody's shoulders that's here or online, but I mean, at least for us to get an initial thought, because like once again, we are the first council. This wasn't even this expedited process was not offered to the other council preceding us. And so we are the first council to be offered this expedited process, utilizing the formula that Jamie was talking about. So in that case, it would move fairly fast within the process, and it would move almost alongside of the 1907. And when we did go back to membership, if we did receive and we had anticipate receiving a final settlement amount, we would then still have to follow that same process that we have to with the 1907 in going to the membership and the membership accepting the amount, as well as options for individual as well as the collective payout. Jamie, there was a question about, do you know the reason for the expedited process?
Because there's so many agricultural benefit claims. As I said, I was involved in the development of a framework through mediation. There'd been another treaty area that was settled on a framework. It was slightly different formula in terms of Treaty 8, but because all the First Nations have essentially the same claim, Canada didn't provide the agricultural benefits that the First Nations were entitled to. It was thought that the same sort of settlement approach would be offered to each First Nation because the basis of the claim was the same.
Does that answer your question?
Answer? Okay, Babsy. Gary.
Gary Bowes. Question is, are we changing our lawyer? Are we tying this question together and like two questions into one or what?
Well, no, we're going through a procurement process regardless for legal. So there is not, so for anything legal for Cowessess, we're going through a procurement process.
So we are changing our lawyer.
We don't know because Braban and Company will have the same opportunity as any other legal firm in their letter of interest.
So if we say yes to the cows and plows, to the first one, right? To submitting the claim. We are going through the process anyways, you're saying? Because the way it's written there, it says you agree to this, and if so, we will continue. So if we don't,
well, we are going, okay.
If we don't agree with that, do we still go with the procurement?
Well, we are still going to procurement anyway for all legal. So how
If
about this?
so-
How about this? Corey, just take that second part out of there so that there's no confusion. Because I don't want there to be a confusion. So just erase that.
Oh,
The important question is that
yes.
because regardless of the fact if we move forward or not, we're going through a procurement process.
Yeah.
It has nothing to do with the first question.
Oh, okay. Now we're talking lawyer, right? Procurement process for a new lawyer?
No.
Oh.
We already have received indication from Canada. And this is a completely different claim than the 1907. So it is not piggybacking off the 1907 or anything else. It's the 1907 claim, and that is with Braban and Company and Madison Twos. Okay. Any other further legal, we are going to out for procurement in order to get the best deal for Cowessess.
Okay, emphasize that best deal for Cowessess. Yes.
Pardon me?
Yeah, best deal for Cowessess.
Yes.
Whether it be Al or whoever shows up, because like I say, for 30 years, Al's been with us, First Nation, knows us inside and out. And like, you know, a little black bear, that's where he's from.
And that will go in his favor during the procurement process if he does choose to put his name forward or his company's name forward.
It's because I know the last time somebody tried, at a drop of a hat, it cost us 800,000.
Oh, I can give you my guarantee as chief that there is no process that would ever happen like that under myself.
Just a heads up, that's what happened last time we tried to change it.
Oh, and yes, we are very aware, and that's why we're actually going through procurement, is to ensure that Cowessess gets what it deserves And so we may be privy to information that other membership doesn't have, but I can guarantee you on my oath of office, my interest in being here is the best deal for Cowessess. And I can say that I feel the same thing for the team. Our loyalty is to Cowessess, not to a law firm.
Okay. Does that answer your question, Babsy? Or you'll just wait? Yeah? Okay. Okay,
So-
can we get Lucy here? She wants to ask a question related.
So, the question that you're posing is, do you want the chief and council to pursue further claims against the government? And I would say regardless of the claim, you pursue them and you pursue them and you pursue them. We get an opportunity to say no when the ratification comes. So as the government, you keep pushing that envelope and just keep pushing all the claims. And in respect to the professional services that we get from legal firms, accountants, it's like having a good governance in place. You put out invitational tenders, request for proposals, and give an invitation to all of those to bid on services for your area, whether it's legal or accounting or appraisals or whatever. Those professional services have to remain objective. And they also have to remain fair in respect to our affordability, because if firms get bigger and bigger and bigger and start charging bigger and bigger fees, then their clients get bigger. Sometimes older clients stay behind because they can't afford to pay those fees. So for just having good governance practices keeps our existing lawyers and any future lawyers to be fair and honest as they go forward, and to maybe adjust their rates, maybe give some pro bonos instead of charging the nations endlessly. Because if you do an actual assessment as to how much legal fees that all the nations in this country have paid to law firms, and did we get the value for the services? On some occasion, no. And on some occasions, we've gotten way better value than what we paid for, depending on where the heart of that firm was and where they were in all of these claims. Now, I know we have a very long relationship with Brabant and Company. And prior to that, it was the law firm that made him the lawyer that that we had the Wallace and Tom Waller, right? That we made rich with our first TLE claim. And let's accept the fact that any lawyer that's going to work on our claims is going to make money. And there's nothing wrong with that. Thank you.
Good, that's two questions about the lawyer. Patrina had a question.
My question was right at the beginning, and why haven't we filed a claim? But you're asking membership to pursue the submission. So what do you say, membership? Should they pursue it?
Yes,
Yes.
yes, anybody? Yes, everybody say yes, whoever is ready. Good.
Okay, and part of this, like I said, we're the first council that this has been brought to us. And there's been a lot of information out there about if those who are going for the cows and plows, those are, that are looking at those types of claims, it's going to impact treaty and inherent rights, especially treaty rights. And we honestly did not want to have that on our shoulders in just moving forward. Now, once again, we wanted to bring that to have the discussion with the people. And then we have no problem at our next duly called having a BCR and pursuing a claim, whether or not we accept it. We could refuse it at any point. Pasqua First Nation is First Nation that we can look at that's actually very recently done that. They've submitted their claim. They've gone along with their legal process. And there's one area of contention within that agreement. And they have actually walked away from the table right now until it's settled with Canada before they accept that cows and plows settlement. So there's at any point in time until we actually sign it, that we could say no, because there is precedent right now. So we feel that, you know, overall for us as council, we feel that there is no detriment and there's no loss on us moving forward with just submitting a claim. But we wanted to bring it to the people so that you know that we've contemplated heavily. We've listened to the podcasts of the people that have said it. We've sat with Saul Sanderson for a day. You know, we've done a lot of educating on the issue of the agricultural benefits. But the bottom line is that with some of the, you know, with the information that Jamie gave us, there is nothing that we will lose or nothing that we will be held to if we submit and get in that queue right now.
Online, Denise, I suggest go ahead. Krista, go ahead. Emlara, hang on. All of them say go ahead, every one of them. Down at the bottom. Find it. Any questions here?
Mine's only about the questions with the lawyers to expedite the whole process. Is that also going to be a cost, an extra cost
No.
for lawyers? Okay. Because you know how they are. Move it along faster, costs money.
No, in fact, because most of the work is done, we expect that the cost for the going through the process of the ag bans is actually going to be very minimal to Cowessess First Nation. Because of the expedited process and the framework of the predetermined formula and the negotiation that's required in that.
The question online from Krista is, so the other claims will be in the process as well, like the treaty annuities? That's besides the...
Well, I think that part of our procurement process, which is not only good governance, as Lucy said, but it's also good business. Because times have changed for First Nations people. This is 2024. What was 30 years ago, where we were lucky to have a lawyer look upon us as an Indian band, or at that time we were called an Indian band, you know, and that they were taking many chances on us and all sorts of things. And as well as that, when we looked at Indigenous lawyers and Indigenous law firms, there were generalities. Now here in 2024, we have many, many instances where Indigenous law firms, they have different lawyers with different specialities. They also have what's called benefit back to the nation, where within their retainer agreement that they will give back 10%, 20% back to the nation of their legal fees for 10 years in order to build parks or water sprays or whatever the case is. There's all sorts of benefits to nations where 30 years ago, it was something for a lawyer to take a chance on us. We're in the driver's seat now. We are the ones that are the big money, big business. And as such, in order for us to do our due diligence for the best interests of Cowessess members, we have to open up that playing field, and we have to give opportunities so that we have greater benefits to our members with the specialties, as well as the expertise that's out there, as well as benefit to the nation. So that's what we're looking at.
Okay.
And that's not only in legal, that's across the board with all services, all fees and services.
Okay, Crystal Misson says yes, pursue. Anna Brass, yes. Kelly Fremont, yes. Audra Boudreau says, I agree to pursue as it is going to take some time. Sooner we start the process to make a claim, the better. Our elders, I was talking with Mildred over in the corner, are leaving us, and we should be the ones who should have benefited. And I think that's what goes for a lot of us. Dodie here. Oh, sorry.
So I think that it's the question you ask is very easy for us as membership here and those online to answer. And that is, a resounding yes for anything that we feel the Crown has breached in their fiduciary duty and responsibilities and relationships with us as a nation. And so I think it's an easy question for them to answer. My next question, it's probably a little more challenging to our leadership that are in the room. And Jamie, I like to include you in this question. What kind of processes are you as chief and council and any experts that you're bringing into this process? How are you going to include your communications or education strategy for the members that aren't in the room or aren't online right now? Because those of us that are here, and I'm guesstimating there's probably about 100 of us totally that are participating today, that represents less than 0.5% of our voting membership. So what I guess our leaderships, and Jamie, maybe lend your advice on this. What are your ideas in terms of getting all of those of us that are going to be voting on this, and those of us that we have to consider, like our elders, our knowledge keepers, our seniors, those that might not be with us to see any true benefits realized in a long term? What are the plans to help keep the membership abreast of all of this? I'm lucky that I'm really curious about our history, and so I spend a lot of time reading about it. And I like the fact that we have people like Terrence here to help us learn all this stuff. So how are we going to make sure that the membership fully understands what these kind of claims will look like for them? Because the one thing I'm noticing, there's a lot of people out there that that say, I didn't hear about this till just now. And to me, that speaks to a gap in our education of our membership and our communications with our membership. So are you guys giving much consideration to that? And Jamie, what have you seen occur in these kind of processes that might give us some ideas for success?
Do you want to go first, Jamie, or do you want me to go first?
It's up to you. I can just talk a little bit of what I've seen. It's always a delicate balance when you're actually negotiating claims, because the negotiations themselves are confidential. But First Nations are allowed to share information with their members. Some use social media, some provide newsletters and communication. But as part of, once there is an actual formal offer and a ratification process, as part of the ratification process, you will be required to try to reach all your members to provide them with an information package, either electronically or by mail. And there's also a requirement as part of the ratification that you hold at least one information meeting in the community. But most First Nations also hold information meetings in urban centers where they have a lot of members, as well as virtual sessions. And in my experience, it makes sense, and it provides the best chance of success if you start informing members and holding meetings even before there's a formal offer or a formal ratification process. So it's really the best advice I can give is just do this kind of thing, where you hold meetings with the community. People can come out, allow people to come in virtually, and just make it as accessible as possible for your members. Chief, I know you have some thoughts as well.
Thanks, Jamie. And I guess this, like Jamie said, for us, this is the first step, because this wasn't really done for us before. Even to ask the question, do you want us to do this? And yes, we might only have 100, and True Cowessess style only have 100 to say yes, go forward. But that's the kind of thing that we're looking to change. And so as we're going through all of these nation talks and the different areas, what we're looking at are creating task forces. And in these task forces, they're going to have key action items. And in this, when we look at us putting forward the ag bans, now that we're going to put forth the ag bans, that this task force, part of it will be that education and training and having different meetings. We're also going to, urban membership have asked us to, that live in different cities, to come out more than once. a year. And so we're looking at going, I think, this summer sometime, as well as the time of our powwows, and using a strong communications and a strategy, as well as being available to answer these questions along the way. We know that there is the benchmark, like Al had talked about, in regards to what we need in order to pass ratification. But for us, in everything that we do with governance, what we're really trying to do is raise that bar and put in standards even for ourselves that are not there by the Indian Act or not there by the government, that tell us what will pass and what won't pass, that we create the standards ourselves, which will be, I would believe, at least what the government asks for us to exceed, which then puts it on our shoulders for us to do better by our membership.
More question?
I think I mentioned this last week too about invalid treaty cards, like when they're expired. Will that affect anything to do with anything with voting? And if you don't have a valid one, does there?
Well, you need it's, first of all, they're not treaty cards, they're status cards. But status cards that are expired, I do believe that when we go and vote, we're able to use other cards that are not expired, such as a driver's license or a passport. Or else you can also have guarantors that know exactly who you are and that could vouch for you as well. There's different forms. As well as our urban office here in Regina is doing an amazing job for certificate of Indian status as status cards or status card clinics every now and then. So we really, those book up fast. So as soon as you see them online or you see them in, because I know that they have them in the urban office on their bulletin board, sign up as soon as you can because they do get filled up fairly quickly.
Very, Babsy, Pelchy.
No, just a request, like I asked before, to have the presentation back home on reserve, like being agricultural benefits. We lost them back home. 1907, we lost that back home. Can we have this be presented back home?
Absolutely. And in fact, those were lost on our home reserve, but I have to disagree with you. Every single one of us lost, whether or not we live on or off reserve. Every single one of us lost those benefits.
Yes.
So it's not just back home, and that's why we have the Zoom, so that people back home are able to participate here as well. Just like we expect our 3,500 members to Zoom in to learn as well about what happened. But
Yes.
when we talk about the task forces, this is not a like a one end to everything, is that there will be meetings in different places for people to be able to sit and to be able to contribute.
Yes. Just like off reserve, much respect. I learned my trade off reserve. I spent many years off reserve, but now I'm back home. And yes, we all lost that. I recognize that, but it is back home. Cowessess is over there. So thank you if we can have this
Of course.
presentation back home.
And you know what? I go further to say that Cowessess is inside all of our hearts. And there's so many of us that have not been able to live back home. And I'm back home now and I probably will never leave. So you're talking to a person converted, you know, that I will never leave our home nation, but also within the fact I also am tasked with the responsibility as chief, that it's not only our 800 people that are back home, it's all of the 4,500 members that we have, that we all have equal access and that we've all lost equally for what we're trying to reclaim right now.
Good. Yep. All right. Well, we have one from Tracy Gradlorm. People should have more clarity regarding the agricultural benefits, more so in the area of treaty rights, as there are so many assumptions. And she's asking for an information night, something like what Gary's asking for, an information night just on that.
Yes.
And then, they're gonna upload the slides. So I guess they can read the slides when they get them. You're gonna do that? Okay.
Yes, well, definitely. And like I said, this isn't a one-all be-all.
Yes,
And
that's right.
this is just the beginning to kind of get the, yes, do it, because we still have many months in order to have our, to establish a task force and to get the meetings going and happening for sure.
Good enough. I think she wanted to know a clear yes or no, and we got yes.
Yes,
To move ahead, move ahead. Yes, 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 yes.
Yes.
Yay!
put it in. All right, council, we have our direction.
What you? Him. You have a question? No, you're just looking like that. Okay, he's okay. That other chief besides me. Okay,
So that's it, guys. And we look forward to seeing you if you're not in person on Zoom tomorrow night. As we discuss, tomorrow night is health. It's health, right?
yeah, health and well-being, isn't it?
Health and well-being tomorrow evening.